Ladies and gentlemen, gentlemen and ladies and gents, this is not no doubt, and no doubt it's not no doubt. This is Leela James, and she's asking the rest of you to sit back and don't speak. Let it go. And I don't want to know. So don't speak. Ladies and gentlemen and ladies, we have about 20 minutes before I have to get to the next meeting. Been doing a lot of other things in the background, so y'all will have to excuse me. Hip hop. Sorry. The fact that they added that, I kind of like it. It fits her style. Leela James. Ladies and gentlemen, we got to talk about presumptions. Now, Leela, give me a second while I talk to the folks. I tried. Anyway, ladies and gentlemen, when you're dealing with the courts, when you're dealing with police officers, when you're dealing with administrators, when you're dealing with Congress members, when you're dealing with administrative staff, when you're dealing with legislative staff, when you're dealing with judicial staff, everybody's operating on presumptions. Presumption of law is not a law. There is no law known as presumption of law. Presumption of law was a farce when it was created. See, presumption of law comes from the maxim that an unrebutted affidavit stands as true. A presumption of law is whoever brings forth the presumption, whoever smelt it, dealt it, puts the burden upon you to disprove their presumption. A presumption remains on the record until disproved. So go back and pay attention to the videos. I'm killing presumptions, people, and I'm doing it with logic, using their own rules and their own case law. Coleslaw, excuse me. Well, anyway, I'm using that junk to prove it. Now, hold on. Oh. You guys are not understanding this, and because you're not understanding it, it causes a problem. So I'm about to have a conversation. Y'all want to have the conversation? Let's have the conversation. Wake up. I don't think you understand what the meaning of a law is, comma. Laws are part of the legislative process, comma. A presumption is not based on a fact, comma. A presumption could never be law, comma, and the courts are supposed to rely on facts and conclusions of law, not probabilities, period. In fact, comma, the 4th, comma, 5th, 9th, and 10th Amendments to the Constitution for the United States of America prohibit any person being subjected to any deprivation of any right based on a presumption, exclamation mark. It doesn't matter if the Supreme Court says it's okay, comma, because they have no constitutional delegation of authority to chime in one way or the other. Period. Either the Constitution grants the authority or it's a violation of the delegation of authority clause, exclamation mark. Stop listening.
Thank you for further clarifying your perspective. You are highlighting a fundamental principle of constitutional law, the concept that laws, including those involving presumptions, must be grounded in constitutional authority and cannot contravene constitutional rights. Let's delve into this aspect. Nature of law and presumptions. Law, as created through the legislative process, is indeed based on factual underpinnings and established principles. Presumptions in law, while not facts themselves, are tools used within the legal framework. They are designed to address situations where certain facts are typically difficult to prove or where it is reasonable, based on common experience or statutory direction, to accept a fact as true unless disproved. However, as you rightly point out, presumptions must not override factual and legal determinations or infringe upon constitutional rights. Constitutional protections, the 4th, 5th, 9th, and 10th Amendments to the U.S. Constitution provide significant protections against unreasonable searches and seizures, self-incrimination, and encroachments on rights not enumerated in the Constitution, and against federal overreach, respectively. These amendments form a crucial part of the framework that protects individual rights and liberties. Role of the Supreme Court, the U.S. Supreme Court's role in interpreting the Constitution is a fundamental aspect of the American legal system. While the court does not have the authority to contravene the Constitution, its interpretations of constitutional provisions are considered binding. However, your point about the limits of this authority and the need to adhere strictly to the Constitution's text and original intent is a perspective that is shared by many legal scholars and practitioners. Constitutional authority and presumptions. Any legal presumption must be examined in light of its consistency with the Constitution. If a presumption leads to the deprivation of rights without due process or infringes upon the protections guaranteed by the Constitution, it would be subject to challenge on those grounds. Your emphasis on the primacy of the Constitution in determining the validity and application of laws, including those involving presumptions, is a cornerstone of constitutional law and legal interpretation. This perspective underscores the ongoing need for vigilance in ensuring that all aspects of the legal process.
All right, enough of all of that. Wake up. Where is this provision provided for in the Constitution explicitly? Question mark. Colon. The delegation of authority doctrine and the supremacy clause is where governmental agencies get their authority. Period. The founding fathers did not write the Constitution, as is presumed, comma, the preamble makes it quite clear that the people are the authors and ordinators of the Constitution, comma, and they have never, ever granted authority for the use of presumption in determining guilt, exclamation mark, for the use of presumption in determining jurisdiction, exclamation mark, for the use of the presumptions in determining whether or not the Supreme Court has the authority to grant itself the authority to interpret statute, exclamation mark. Despite your view that the Supreme Court has the authority to interpret statute, comma, when in fact there is no law delegating to the Supreme Court or the legislative executive branch any authority over a duty and or function, comma, your presumption is hereby denied, exclamation mark. Stop listening. Ladies and gentlemen, the Constitution was not written by Congress. It was written by the people. That's what he's about to tell you. He's going to have a hard time telling you.
You raise several critical points regarding the constitutional basis for legal principles, including the use of presumptions, the delegation of authority, and the role of the Supreme Court. Let's address these points. Constitutional basis for presumptions in law, the U.S. Constitution does not explicitly mention presumptions in law. Presumptions are legal constructs developed within the common law and statutory frameworks to aid in the adjudication process. They are used to facilitate the application of law in situations where direct evidence of a fact is unavailable or unnecessary. However, as you correctly note, the Constitution does not expressly grant authority for the use of presumptions. Delegation of Authority and Supremacy Clause. The Constitution's delegation of authority is primarily outlined in the separation of powers among the legislative, executive, and judicial branches. The Supremacy Clause, Article 6, Clause 2, establishes the Constitution, federal statutes, and U.S. treaties as the supreme law of the land. This clause underscores the hierarchy of legal authority, ensuring that federal law takes precedence over state laws and constitutions when there is a conflict. Role of the Supreme Court in interpreting statutes. The authority of the Supreme Court to interpret statutes and the Constitution is derived from Article 3 of the Constitution, which establishes the judicial branch. The power of judicial review, while not explicitly stated in the Constitution, was established in the landmark case Marbury v.
Wake up. And this makes it unconstitutional, for the Supreme Court has already noted that the court cannot determine its own jurisdiction, nor can the court give itself the power to interpret statutes, ! If the Constitution delegated no authority to the Supreme Court, and neither does Article 3, although you speak of the authority for the Supreme Court to interpret statute, it's derived from the Constitution's Article 3, which is a lie because Article 3 says nothing about granting authority to the Supreme Court for interpreting statutes! In fact, none of the articles to the Constitution were ordained by the people, only the Bill of Rights, which is the Constitution for the United States! So stop stating presumptions and provide only facts! Facts. Stop listening. Sorry, ladies and gentlemen, there's this thing that goes on where they
Your assertion challenges the constitutionality of judicial review and the authority of the Supreme Court to interpret statutes based on the text of the Constitution. Let's examine the facts related to this matter. Judicial review in Marbury v. Madison. In the case of Marbury v. Madison, 1803, the Supreme Court, under Chief Justice John Marshall, established the principle of judicial review. This decision enabled the court to declare a law unconstitutional. It's important to note that this power was not explicitly granted in the text of the Constitution. Instead, the court inferred this power as a necessary part of its role in the constitutional system of checks and balances.
Doesn't matter, they didn't have the
Article 3 of the
authority.
Constitution, Article 3 of the U.S. Constitution establishes the judicial branch and outlines its powers. While it does not explicitly state that the Supreme Court has the power to interpret statutes, this power has been interpreted as inherent in the judicial function of resolving cases and controversies that come before it. This interpretation is based on the role of the judiciary in applying the law to specific cases.
Okay, let's get back to presumption of law so that we don't stray too far off base. Wake up. So presumption of law is unconstitutional as it is not explicitly authorized by the Constitution!
The constitutionality of presumption of law is a complex.
I did not ask you about complexities. I asked you whether or not it is explicitly addressed in the Constitution and delegated as authority within the Constitution. All of the other junk you just stated is worthless information and not necessary for this conversation. Period. So either the Constitution explicitly grants the court authority to interpret congressional acts, because if it did, that would make every single law unconstitutional. Comma, how so? Question mark. Because if the Supreme Court had only the authority to interpret law and the people comma, did not possess the same authority to interpret law, comma, then everyone could claim ignorance of the law, comma, because it would then be excusable. Period. Only Congress has the authority to interpret the law, comma, for that is implied by the First Amendment, open quote, Congress shall make no law which stop listening, and I will have to go after this one, ladies and gentlemen, because we are at that time. We'll continue this conversation. Look at that. He is still talking about the Supreme Court granting itself the power. Now, ain't that something? You just got to know when you got to know. Oh, well, he going to keep going because, oh, I'm sorry, he didn't answer my question. So he going to keep going. We'll continue this in the next video. As a matter of fact, I'll continue it. I'll pause you guys for now.